right, so today's topic is criminal law, so let's go ahead and get started. So criminal law, a wrong arising from a violation of a public duty is pretty much the definition of a crime. So if you are the victim of a crime, you are not called the plaintiff, you are called the complainant. The burden of proof in a criminal case is not the same as the burden of proof in a civil case. So remember, from torts, the burden of proof is not as high. The burden of proof is simply a preponderance of the evidence. The burden of proof in a criminal case is different. So it's beyond a reasonable doubt. So if my hands are the scales of justice, a preponderance of the evidence in a tort case would look like this. Beyond a reasonable doubt looks more like this. So the evidence must be clearly stronger in a criminal case. So crimes are classified according to their seriousness. A misdemeanor is less serious. So a misdemeanor is punishable by up to a year in jail. A felony is more serious. It's punished by more than a year in prison. Crimes also require a requisite mental state, or a mens rea. So if you've ever seen Legally Blonde, there's a pretty good discussion of mens rea in that movie. Mens rea generally requires that the defendant didn't act voluntarily and that the act is criminal. All right, so consider this. What if Mary eats peanut brittle and later she kisses Tom? It's a mutual kiss with mutual consent, and Tom dies because Tom has a peanut allergy. Has Mary committed an offense? And the answer, of course, is no, she didn't have the requisite mental state, right? So if Mary did not know that Tom had a peanut allergy, then Mary may not be convicted of an offense regarding his death. This is a question that's often asked by students. So what about intoxication? Intoxication is not a defense to a criminal prosecution. All right, so parties to a crime. As a rule in Virginia, everyone who takes part in the planning, execution, or cover-up of a crime may be convicted of that crime. So let's say that I have hired you to be my getaway driver, and I'm going to go rob a bank, and we're caught, and I'm prosecuted for attempted armed robbery. As an accessory, can you be prosecuted for attempted armed robbery and you never went in the bank? And the answer is yes, you could. Responsibility for criminal acts. Just a couple of points for you to remember. This is often asked on the major field test. An employer may be held liable for the crime of an employee when the employer directs the employee to commit the crime. So just a couple of questions to go along with this. Is the employee also guilty? Yes. May a corporation be held guilty of a crime? Yes, and oftentimes we see with environmental protection statutes that corporations are found guilty of criminal acts. How about this? May the CEO be prosecuted? And the answer here is yes. U.S. versus Park is one of the cases that stands for this proposition. Attempts and conspiracies. So an attempt, so when you hear someone being charged with attempted armed robbery or attempted murder, an attempt is something less than the crime but more than mere preparation. So for instance, what if Mary tries to poison Tom and fails? Then she has the requisite intent and she will be charged with attempted murder. Conspiracy. Conspiracy is an agreement between two or more people to commit a crime, and so conspiracy is the agreement itself. And so since that is the case, withdrawal is not a defense. And so it does not matter that the crime was never completed or that perhaps it was thwarted. The Racketeer Influenced Corrupt Organizations Act. This is an old law, dates back to 1972, and it was aimed at organized crime primarily, at least initially. And so what RICO applies to is it requires the forfeiture of, or it includes the forfeiture of crime-related property. So in other words, let's say that you sell, actually I'll tell you a real story. There was a lawyer in South Carolina in the early 1980s who was involved in racketeering. He was selling drugs, and his office was on Hilton Head, South Carolina, and he had a law office, and his law office basically was a front for a drug trafficking operation. So this lawyer gave his mother a car, in fact, a brand new Cadillac. And he was caught, and he was prosecuted. He posted bail, and he fled, and no one has seen him since. I'll tell you, his first name was Tommy. No one has seen him since then. But after Tommy fled, the feds, the U.S. Marshals, came knocking on Tommy's mother's door. She actually was a nice lady. And they told her that we're here to get the car. And she said, well, you can't have my car because my son gave it to me as a gift. And they said, yes, the car was purchased with money that was obtained through drug trafficking, and so we're seizing it pursuant to RICO. And so the question is, can they do that? And the answer is yes. So money that is purchased with property that is purchased with illegally obtained money, or property that's used in connection with the commission of virtually any crime, and these crimes are considered to be racketeering activities, then they may be seized pursuant to RICO. So you may see there are a lot of U.S. Marshal sales where valuable car collections are sold, or incredibly nice airplanes or boats. These may very well be seized pursuant to RICO. All right. So here's your hypothetical that may or may not appear on the test. So let's say that for graduation from high school, your parents gave you a brand new car. And you've decided that while you're off from school, that you're going to run drugs up and down the I-95 corridor from Florida to Virginia. And you're caught in South Carolina with a trunk load of marijuana. Your car is then seized pursuant to RICO. Can your car be seized? And the answer is yes, it can be seized, it can be taken away from you, even though you did not use drug-related money to buy the car, it can be seized. So RICO calls for forfeiture of crime-related property. It also calls for a $25,000 fine per violation and or up to 20 years in prison. Other white-collar crimes, a couple of them I just wanted to mention. Mostly you just need to be able to identify these. Money laundering. Money laundering, when I was your age, I thought that meant I left $1 in my jeans pocket and washed it. Money laundering involves concealing the origins of illegally obtained money, concealing them in such a way so that you can spend them and they can be part of the economy, the legitimate economy. Oftentimes money laundering involves washing money through foreign bank accounts. If you'd like to see more about money laundering, the BBC produced a short video. It's about 3 minutes long, and I've included a link to that video. Bribery is defined by Black's Law Dictionary as the offering, giving, receiving, or soliciting of any item of value to influence the actions of an official or other person in charge of a public or a legal duty. The bribery laws have been expanded to include paying a player to throw a game or to control point spreads. The Foreign Corrupt Practices Act. Now this act was first considered in the wake of Watergate. So Watergate was the big scandal in the 1970s, and what happened was that after Watergate, the country was fed up with corruption, and so there was an investigation, and a special prosecutor uncovered secret slush funds that were used by U.S. corporations to bribe foreign public officials in order to obtain contracts. It was not illegal at the time to bribe a foreign public official. So in other words, in those countries, really until fairly recently, in many countries, it was not illegal to pay a bribe to a foreign public official to obtain a contract. So the Foreign Corrupt Practices Act made it illegal for U.S. businesses or U.S. citizens doing business abroad to bribe a foreign public official in order to obtain a contract. It's a sui generis law, which is sort of an interesting concept. It's a United States law that is applied overseas. And this law has a twofold approach. One includes accounting provisions, so if you happen to be an accounting concentrator, you will talk about the Foreign Corrupt Practices Act in your classes. The second is an anti-bribery provision. Again, I said that it is illegal to bribe a foreign public official in order to obtain a contract, but there's a small exception to the rule, and I always ask you about the exception, and here it is. A grease payment paid to a low-level public official in order to have some sort of a ministerial duty accomplished is specifically excluded. So in other words, it's legal to make a small bribe to a low-level public official. So here's my example. I've done this, but only once. We have a house in the Bahamas on Green Turtle Key, and the Bahamas is it's corrupt. In many ways, it's corrupt. And so we built a house down there that's an investment property that is rented, and we first went down to see the property around the year 2000. So we get to the Green Turtle Key. It's Christmas Eve. I have small children with me at that time, and there's no power, no electricity. That's huge down there because the water comes from a cistern. A cistern is simply a large holding tank, and that our house was built on. So it has a 40,000 gallon, essentially a swimming pool underneath the floor of the living room. And that's our drinking water. And you need electricity to get the water to the faucets. So anyway, not having electricity is huge. I got there and I said, oh, I can't believe we don't have electricity. I've paid all the proper fees to have it turned on. I have all the licenses. The house has been inspected. And my property manager said, yes, but you need to do one last thing. And I said, well, what is that? And she said, you need to pay a bribe to the local official. The power company in the Bahamas is part of the government. It's Bahamian Power Company. Anyway, so I said, oh, I am so offended by that. And my property manager said, well, you can be offended, but you will never get electricity unless you pay this bribe. All right, so I said, how much is it? And she said, $200. And she said, if it will make you feel better, we'll call it a Christmas bonus. And she said, I need $200 cash. Anyway, I gave her the $200 cash. She went and paid the low-level public official. Within 10 minutes, my lights were turned on. This is an example of a grease payment. I did not violate the Foreign Corrupt Practices Act. It's perfectly legal. Other white-collar crimes you need to be familiar with. Forgery. That's signing another person's name with the intent to defraud. So there must be intent to defraud. How about this? Your mother gives you her credit card. You're going to go out and buy new clothes for the fall, and she's given you permission to sign her name. Is this forgery? No. Perjury is knowingly giving false testimony after being sworn to tell the truth in a judicial proceeding. Here's my question for you. Must you be in a courthouse to commit perjury? And the answer is no. So you could perjure yourself during a deposition or during interrogatories. Anytime you're sworn to tell the truth, if you lie, you've committed perjury. Embezzlement is misappropriation of funds that are placed in your trust. So, in other words, money or property has been entrusted to you, and yes, you have the right to have control over it for that period of time, but you decide to take that property and use it for yourself. That is considered to be embezzlement. And then finally, last white-collar crime you may have to identify is receiving stolen goods. So the point I want to make with receiving stolen goods is that you do not have to have actual knowledge that the goods are stolen. You just have to have reason to believe that they are stolen. All right, so this happened over 20 years ago. You don't remember this, you don't recall this, but flat screen TVs used to be incredibly expensive. And so a flat screen TV that we would pay $300 for today would cost $10,000. At any rate, there was a truck parked out on the edge of campus, and it was unmarked, and it was full of flat screen TVs that would have been thousands of dollars in the open market, and the person was selling them for $200 each. My daughter was in high school at the time, and she happened to be at Longwood taking a class, and she walked by this truck. And she hurried into my office, and she said, Mom, we can buy a flat screen TV for $200. Just give me $200 cash, and I'll go down and get it. And then she told me the story about where the TVs were and where the truck was. And I said, no. And she said, well, why not? And I said, those TVs are not. Those TVs are hot. In other words, they're stolen goods. And she said, well, how do you know? And I said, well, they're $200, and they should be thousands of dollars. And I said, if you were to buy one, then you've committed a crime, and that's receiving stolen goods. She understood, and that was the end of that. But anyway, my point is this: actual knowledge is not required, just a reason to believe that the goods are stolen. Lotteries. Remember, we talked about lotteries with contracts. Lotteries have three elements: prize, chance, consideration. You're giving away a prize. It's strictly by chance that someone wins that prize, and there must be consideration. In other words, you must pay to play. In Virginia, you have to be properly licensed in order to operate a lottery. I wanted to point out that a charitable organization can have a raffle, essentially a lottery, if it earns less than $40,000 a year, and you would not have to be properly licensed. Last slide of the day, and probably the most interesting one. So reporting white-collar crimes. There's a law, a very old law, sometimes referred to as the Lincoln Law. Dates back to the Civil War. It's called the Civil False Claims Act. And if you uncover a corrupt government contractor and you are the whistleblower, you may be able to recover between 15 and 30% of the damages that were recovered from that corrupt government contractor. So that's your reward. So let me briefly tell you about Evelyn Noob. If you'd like to click on the link, you can read more about Evelyn Noob's story. But Evelyn Noob worked for Blue Cross Blue Shield of Illinois, and she'd uncovered corruption. In fact, it made her feel very uncomfortable. She had been asked to shred Medicare claims, to put boxes of Medicare claims in a dumpster. Anyway, there was a corrupt government contractor, and they were ripping off the government for millions of dollars. Evelyn Noob was under a lot of stress, and her employer had threatened her, if you turn me in, you're part of this too, you're going to prison. And she didn't quite know what to do. So under extreme pressure and a lot of stress, she went to see an attorney, and the attorney told her, well, this is corruption, and so you can report, you can file what's called a qui tam lawsuit, and you can report this corrupt government contractor. And in fact, she did. And Evelyn Noob was awarded, her share was $29.1 million. So anyway, if you ever work at a place and you have a corrupt government contractor, you may be able to recover under the Civil False Claims Act, also known as the Lincoln Law. And so that's it for part one of crimes. Part two is next, and part two will be coming soon.